of the victory we had in Georgia, where economic liberty was said to be an unenumerated right under its due process clause, but it was a victory against the laws or the state's lactation consultant license, which the court unanimously found to be unconstitutional under a standard that is a higher standard than the federal rational basis test. And we also had an argument, I think it was earlier this week, my colleague Keith Neely argued at the Louisiana Intermediate Appellate Court, where Louisiana has a license for braiders. So this is a little bit like the other litigation we've done in the past about cosmetology laws requiring people who just simply braid hair to get a cosmetology license. Here they actually do have a braiding license, but it is far and beyond what one needs to actually earn a living, and it doesn't make sense for what the braiders need. It's 500 hours of instruction with nothing in the law about what you're actually supposed to learn, and so that will be pending in the Louisiana court system, and that may go higher after that. So keep a watch on all of those and other cases, and I think we're going to be hearing more and more examples of like the North Carolina case and the Georgia case in coming years.
Especially after everyone reads your articles.
I hope so.
So if anyone here in the audience has a question, feel free to raise your hand. We'll have one of our trustee legal associates come over. And while we prepare for that, I was just going to read a question that's come in from our online audience. Well, first we got somebody saying, hello everyone, greetings from the Philippines, so that's exciting. Hello to our viewers in the Philippines. But secondly, we have a question here. Is the answer to this problem of courts not protecting economic liberty to give rational basis review more teeth, or is the answer to elevate the right to earn a living to fundamental status, as Judge Ho argued in his concurrence in Golden Glow?
Oh, I definitely think the latter. I think that the right to earn a living is a central part of what we mean by the American dream. It is one of the crucial rights that state constitution makers intended to protect, particularly in these fruits of their labor clause provisions. It's hard to imagine how that is not a fundamental right when it's listed in such terms and alongside other rights that are clearly fundamental. Not to mention that the arbitrary distinction between fundamental and non-fundamental is entirely policy driven. It's entirely based on the prejudices of the legal elite class, which, they make their living with words. Therefore, free speech is a fundamental right. And if all the lawyers out there were also plumbers, plumbing would be considered a fundamental right. It's entirely arbitrary and politics driven. So yes, I would definitely endorse fundamental status, and I think that so-called rational basis with bite is a step in that direction. But we should not leave it at that. And more important, I really don't like this term rational basis with bite either, because there are not two types of rational basis test. The Supreme Court has addressed this specifically and refused to endorse the idea that there are two different rational basis tests. And I think those of us who believe in liberty should be very reluctant to encourage them to do so. Because if we do that, we are going to end up on the short end of the stick, because the legal community is so dead set at present against protecting this fundamental right of economic freedom that if we subdivide rational basis, economic liberty is going to get dropped into the lower category. And I don't think that that's wise strategically as a litigation matter, and it's certainly not warranted by the Constitution, but of course neither is the fundamental, non-fundamental distinction.
Yeah, I try not to use the fundamental, non-fundamental distinction. I think it's a garbage distinction about how rights are protected by state and federal constitutions. As I argue in the book, I'd be happy with a lot of kinds of scrutiny, as we call them, for the right to earn a living and other rights. Any kind of real judging, as Clark Neely likes to say, would be quite satisfactory. A lot of these barriers that are litigated in court that Goldwater and IJ litigate and just regular entrepreneurs have to deal with, something like, if you want to call it intermediate scrutiny, medium rare scrutiny, as my old professor Mike Paulson likes to say, whatever you want to call it, if your judge is looking at real facts and ends means fit and that kind of thing, that's going to take care of a lot of these problems, whether or not you ever get to the strict scrutiny level.
Strict scrutiny for all laws, that's what I say. All right, questions from the audience?
Yes, you both touched on the homogenization of state constitutional systems with the federal constitution, and my question is really simple. It's just, is time of the essence here to take advantage of the strategies that you outlined in your talk here and in your drafts?
Is time of the essence? Well, I suppose, justice delay is justice denied. So, of course, time is of the essence of every litigant, and that's no less true of an entrepreneur who wants to put food on the family to feed his family and can't because the government imposes some ludicrous licensing requirement, like in Louisiana, where you have to get a license to be a florist. You have to get a government permission slip to arrange flowers for money in the state of Louisiana, in the free state of Louisiana. It's repulsive. Or the con laws that say that you can't run a moving company unless you get permission from all of the moving companies that are already operating in the state. And you know what? They're not likely to approve of their own competition. Some of these laws are so insane, and yet the only reason why they exist is because judges refuse to take these issues seriously, and that's because of the rational basis test. And the rational basis test is a purely politics-driven, policy-oriented act of judicial abdication that cannot be justified on the basis of state or federal constitutional history or text or philosophical principle.
To your question, I don't know if time is of the essence that this is a moment in politically or jurisprudentially that's quite different than other moments in time in pushing for the right to earn a living in state constitutions. I will say though that the whole textualist revolution, originalism being a big deal in the current generation of lawyers. To some extent, that is going to have the unintended or unforeseen consequence, and it is already, of a lot of these judges who, when they were lawyers or law students, said, I believe Justice Scalia, and I think textualism is the way to go, and you should read the text and take it seriously. And now a lot of those people are getting to be judges in state courts, and they're reading things like, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. There's the text. What does that mean? Now, some of them already have kind of shied away from that. Well, there's text and there's text. But a lot of them, I think, are going to be true to that, and in some cases already have, and are going to take state constitutions seriously in a way that the past U.S. Supreme Courts have not. I don't need to enumerate all the times that it haven't, but the cases I'm talking about. And so because of that case law and because of the federal government being what it is, the U.S. Supreme Court isn't maybe likely to move in that direction in some ways. But at the state level, there's all this freedom for these textualists to take this text seriously. And I think in that way, I'm quite hopeful for the coming years and to see what comes from that.
Although it just occurs to me, perhaps you mean by time of the essence because of the Dobbs decision and the nationwide controversy now over abortion rights. That definitely gives us, it's created a real opportunity to argue about state constitutions, what kind of rights they protect. And so far, I think it's very impressive how state courts have been dealing with this. The one that really comes to mind is the Kansas Supreme Court's decision in, I think it's called Hodson-Nauser versus Stewart, I think is the name of the case, on whether abortion is protected under the Kansas Constitution. Now, what's impressive about that decision is they really take these natural rights issues seriously. They're really going into what John Locke said and what he meant, not just as a historical matter, but like, what does this really mean? And both sides, the majority and the dissent, are doing this. And no matter what your view is on abortion, that is an impressive display of legal reasoning. If you think the majority was right or if you think the dissenting opinion is right, they show that judges are capable of doing this. They are capable of addressing this issue, and they may come out with disagreements, as judges, of course they do, because they're human beings, and then the people can decide whether to retain or throw judges off the bench, whether to amend the Constitution, et cetera, et cetera. That's how our system is supposed to work. And I think so far, anyway, the reaction to the Dobbs decision at the state constitutional level has been very, I'm optimistic about it.
Indiana had a case last year that is similar vein.
And I think Wisconsin
abortion.
too, if I remember right. So there's been a number of these states that have been doing this.
Maybe to the questioner's point, there was another related question online about, coming off of this pandemic, that I think the pandemic changed things for a lot of people. It brought home how important it was to be able to make your own working conditions, stay open, even when the government, all of us were really affected, I think, at an employment level in some sense about being shut down. We saw the businesses around us fall. And there was a lot of litigation during the pandemic that I think fared better in terms of economic liberty than usual. And I wonder if there's a special moment presented by that situation as well for economic.
Yeah, and the Trump presidency and the Biden presidency, because whichever side you're rooting for there, it's a testament to the importance of federalism, that the federalist system is designed to be, in some ways, very flexible, to be able to protect us against sudden changes at the federal level. And so, but on the other hand, every generation has their crisis. I mean, when I was in law school, it was Bush versus Gore, and September 11th happened when I was in con law. So that was a heady time to be in constitutional law class. So every generation has its crisis, and so these opportunities are always there for the taking. I hope we take them.
Yeah, I think some people were, some libertarians were disappointed by some of the litigation during the pandemic because courts were, upholding everything and these restrictions are crazy or whatever. But actually, there were some examples of some of these laws being found to be just arbitrary and irrational, even during the pandemic, where you can understand, right? We all remember why judges would be hesitant there, and since then, with those kinds of restrictions having happened, you literally, right, you can't leave your house for certain reasons. Now, in comparison, a lot of these restrictions look kind of, they don't look as scary as or needed as they used to be, especially when we learned that a lot of this, of course, was overreaction, what happened during the pandemic. So in the future, I think that contrast can help give judges some perspective about, wow, I can find this law to be unconstitutional and we're all going to go about our business and things are going to be okay.
I think we have one last question from the audience and then we'll break.
Just to start out, thanks to both of you for a really good talk and for your excellent work in this area. I'm curious if you have any thoughts on why economic liberty is sometimes viewed as a conservative issue or a libertarian issue, and are there things that we can do as litigators to try to frame this in a way that is maybe more appealing across the political spectrum? I do a lot of litigation in Wisconsin. We just swung from being a conservative Supreme Court to now being a liberal Supreme Court, and I worry that if I were to bring certain cases to that court, they may not view it favorably. They might see it as kind of like a conservative pipe dream, but it's never been clear to me why that is.
Why don't you go first on this?
You can close this out then. I think there's two answers. For legal elites, as we like to say, a lot of this, unfortunately, really does come down to the ghost of Lochner. And so a lot of more progressive academics and judges will think about what they learned in law school and that there was this Lochner time and then there wasn't because of FDR in the court, and we can't go back to there because of all the people dying in the streets or whatever used to happen back then. And we saw this even in the dissent in Dobbs, where you can agree with the dissent excoriating the Dobbs majority for all different reasons, and then they have this page about, but we couldn't also protect economic liberty because those were bad times back then, and we realized that was an error. Doesn't that contradict what you were just talking about? So part of that is educating those people in power that is not something you need to worry about. Now, how do you fix that? Well, I think part of it is, and this is a process of accretion, but we bring cases that have compelling stories that aren't about major corporations trying to get rid of health and safety laws. They're about entrepreneurs who can't compete against their big competitors because of how their competitors have used the political process. And we've all know these cases and heard about them. So the more we bring those stories, the more we convince people who are affected by the ghost of Lochner that, Lochner was over 100 years ago. Who cares? I want to protect these people from the state not allowing them to earn a living, and this is a way to do it, and things are going to be okay after that happens. And the more these cases happen, like the one I talked about my colleagues had in Georgia last year, the more we're going to be able to do that.
The reason why economic liberty is seen as a conservative issue is entirely an artifact of the leftist mythology that capitalism is somehow conservative, when in reality capitalism is an enormously dynamic force that actually is hugely liberating, particularly to the people who lack the political influence necessary to gain government favors. They're the ones who need economic freedom, constitutional protections for economic freedom the most, because they don't have the wherewithal to lobby the government for favoritism in the way that entrenched monopolistic entities do. And I think that story is becoming clear to a lot of people, thanks to the work of the last 25 years, led, of course, by the Institute for Justice, and then by Pacific Legal Foundation and at the Goldwater Institute where I work. What we've done is we've, in case after case, demonstrated why it's the entrepreneur, it's the little guy who needs this constitutional protection for economic liberty the most. And the reason why these cases are so compelling, hair braiders or lactation consultants or gardeners or whatever it might be, is because that helps to dramatize to people that these are not abstract issues about how the economy operates. These are fundamental issues of how freedom works for real people in real cases. And if you present those kinds of cases, it makes it harder for the judges to blind themselves with ideological preconceptions.
Well, Tim took the words out of my mouth. I was going to say something to the same effect, that economic opportunity, I think, is seen as something for only the Jeff Bezoses of the world, when in reality it's for everyone. It's the great equalizer in terms of opportunity. It allows the people born into poverty to lift themselves out, and it's something that, you know, I'm all about. Jeff Bezos should be a billionaire. He's done amazing things, but it's also economic opportunity is for everyone. It's something we need to emphasize in our messaging. But with that, our time is running out. We're going to take a brief break for coffee, and we'll resume with another panel.
Thank you.
On the nose, welcome back. I hope everybody enjoyed that first panel. I know I did. And thanks for coming back for our second panel. I think it bears prefacing this conversation by emphasizing what it is that we're talking about here, which is really, it's the ability to put food on your family's table. It's the ability to sustain yourself through hard and honest work. And it's difficult to think of any values that are more, in some ways, uniquely associated with the American tradition. And so it's beyond surprising that we would have to constantly have these discussions about whether these rights are really worth insisting upon, and whether the judiciary should be fully engaged in protecting them. I'm really excited to moderate this panel, in part because, as you move down the path of your career, you become more and more aware that it matters a lot who's coming up and who's going to fill the ranks of the next generation of people who are going to be fighting for the same things that you've dedicated your professional life to. I spent most of my career at the Institute for Justice litigating economic liberty cases. I'm incredibly passionate about that issue. And so I'm incredibly gratified to know that we have a younger generation of people who are thinking every bit as hard about that question of how to protect this right. They're doing so in a way that, as you'll see in a moment, is passionate, it's thoughtful, and it's creative. And it has to be because of the challenge in front of us. There was some discussion on the first panel of the distinction between what I called in my book terms of engagement, real judging and fake judging. And it's difficult to impress on somebody who hasn't actually stood before a tribunal. You haven't stood before a judge or a panel of judges and had an oral argument in a rational basis case, because you would think that fake judging must be an exaggeration. Right? But it's not, and you realize that when you go in front of a court, especially if you've argued a case where there's real judging, like a First Amendment case where the judges are asking real questions. They're like, okay, and they're asking real questions of the government. You actually have to, say something true, and you have to have some evidence to support your points. And then when it's a rational basis case, they don't. And what you begin to realize when you've had experience with both of those kinds of arguments, the cases involving so-called fundamental rights and non-fundamental rights, is that everything depends on what hat the judge is wearing, or maybe a better way to put it is what glasses they're wearing. And if they're wearing the rational basis glasses, if they've convinced themselves that the case involves a non-fundamental right, you get a completely different dynamic and a different exchange with that tribunal than if they put on the other glasses. Oh, it's a fundamental right. Oh, there's heightened scrutiny. Well, I'm going to approach this case. And what you realize is they really can do it when they decide that they are supposed to do it. When I say do it, what I mean is apply something resembling actual judicial scrutiny to the case. And just to sort of underscore really quickly what that distinction feels like, the Louisiana florist law has been mentioned a couple times. I was the lawyer that first challenged that one, and Louisiana really does have a law that you have to have a license from the government to sell floral arrangements. They've watered it down a lot after being sort of embarrassed into doing so, but we lost in court. And I kid you not, like the state lawyers in that case were arguing to the court that a conceivable justification for requiring florists to have a license is the physical dangers of unlicensed floristry, which any sane person knows there aren't any, but because it's a rational basis case, you can still assert it as long as you can do it with a straight face. You can assert that. And there's a case that I've blogged or I've tweeted about before, and some of you have seen. Not a case that I litigated, but it was a case in Alaska, another economic liberty case, where there was actually a colloquy between one of the judges on the panel, it was a Ninth Circuit panel, and a DOJ lawyer in a rational basis case about whether invisible space aliens might be a conceivable justification for some laws. And it really went like this, like, could there be such a thing as invisible space aliens? Yes, Your Honor, I suppose there could. Well, then could that be a justification for the law under the rational basis test? I suppose it could. And so when you've got a judiciary that's prepared to approach a case in such an utterly unserious way, you've got to find a way to sort of knock them out, that's probably the wrong way to put it, to entice them out of that mental orientation and get them in a different headspace where they have a different conception of what their role in adjudicating this case is. And that's what each of the authors for this panel have done in a way that is fresh and exciting, and as somebody who's sort of labored in the often very unrewarding vineyards of rational basis litigation, I'm so excited to hear each of them tell you about the fresh and interesting approaches that they've come up with for how to get judges out of that mindset where whatever it is that your problem is, in this case, it's not my problem. And each of you have come up with a really interesting way to get judges into that better and more engaged headspace. I'm just going to do a really quick introduction because you're here to hear from these guys. To my immediate left is Ethan Blevins, who is a fellow at Pacific Legal Foundation. He clerked for our friend Don Willett, right, when he was still on the Texas Supreme Court. Graduate of Duke Law School and a ukulele enthusiast, apparently, according to his bio. Next to him is Skylar Croy, who's an associate at the Wisconsin Institute for Law and Liberty and was editor-in-chief of the Wisconsin Law Review. And then Josh Polk, who's an attorney at Pacific Legal Foundation, comes to us by way of Alabama. And you were editor-in-chief of the Alabama Civil Rights and Civil Liberties Law Review, right? So without further ado, Ethan, take it away.
Thanks so much, Clark, and thanks so much to Cato for this wonderful event, and I've loved reading my co-panelists' papers and excited to talk about it. The humblest individual receives the utmost protection under our form of government. That's a quote from a largely forgotten attorney named Joseph Heller, not the author of Catch-22, who brought one of the most unwinnable claims to the United States Supreme Court and won it in pursuit of his client's right to earn a living. And his clients were the humblest individuals of their time period. These were Jewish, Polish immigrants with broken English operating a slaughterhouse in New York in the 1930s. There's a slaughterhouse theme. I was just thinking about this. Everybody's arrayed against them, it seems. And so it was with these men, the Schechter brothers. But these unlikely heroes had an unlikely weapon, and they used that weapon to slay one of the most ambitious pieces of legislation of the 20th century, the National Industrial Recovery Act, which was one of the darlings of the New Deal. And that unlikely weapon was the non-delegation doctrine. This was an idea that had never borne fruit among the federal courts prior to the year that this case was decided, which was the Schechter poultry case. Now, the National Industrial Recovery Act said that the president can approve these codes of fair competition. Not coincidentally, the codes were first drafted by the industries themselves, presented to the president, who then approved them. And one of these codes was the Live Poultry Code of New York. Now, the New Dealers needed a test subject for their new experiment, so they picked the most marginalized business with the least political clout they could, probably because they thought they weren't going to be able to fight back. They picked the Schechter brothers and slapped them with about 60 criminal counts under the Live Poultry Code of New York. Now, the New Dealers did not account for Joseph Heller, though, and his unlikely idea, which was that finally there's legislation that violates the non-delegation doctrine. The non-delegation doctrine says that the legislature is the lawmaker under our form of government, and they can't just pass off that duty to an agency or an individual, in this case, the president. And Joseph Heller won that argument. Now, to return to the quote I opened with, he said that the humblest individual receives the utmost protection under our form of government. I think those words were very intentional because he was emphasizing the structure of our government and the separation of powers, and that forms a fundamental bulwark for liberty. The Bill of Rights is important and essential, but we also need to remember that it's the structure of government that provides many of these protections. And the paper that Ludwig and I present today argues that we can use the structure of government, specifically the non-delegation doctrine, and pull this unlikely sword from the stone in pursuit of our own client's right to earn a living, just like Joseph Heller did. Now, the non-delegation doctrine has been cast out into the wilderness for a long time now, at least at the federal level. Many say it had only one good year in 1935 when the Schechter poultry case was decided, but it's experiencing an intellectual renaissance. The Supreme Court, a majority of the Supreme Court, has expressed interest in reviving it. Federal Circuit Courts of Appeal have made the same call, but perhaps most importantly, this renaissance has led to a lot of research about what's happening in the states. And it turns out that the states have very robust and meaningful non-delegation doctrines, and that plaintiffs actually win under them. So we propose that we can use these state non-delegation doctrines to challenge occupational licensing schemes. cronyism and delegation really go hand in hand, because we talked about embarrassing the legislature or body into doing something right, but and the legislature is subject to being embarrassed. They have to make laws in a transparent, publicly accountable way. But they also want to cater to special interests. Well, the way they can do both is by simply delegating to an agency. They pass some relatively uncontroversial bill that says we're going to regulate this industry, and they're going to make this board can make whatever necessary and proper rules it wants to. They're the professionals. And then the agency, which is largely made up of industry incumbents, can favor the special interests. In fact, they really are the special interests. Now, there's two reasons why we think that non-delegation claims can succeed in challenging occupational licensing schemes. The first is what I just mentioned, that these boards are filled with industry insiders, and this is often required by statute. So we're picking on Louisiana today, but the Board of Cosmetology in Louisiana is an 8-member board. Every single member has to be a licensee and be operating in the state of Louisiana. In other words, this is a fully captured board. It's competitors regulating their competitors. Now, that's relevant under the non-delegation doctrine. One of the problems that we have in this world is we all know that these boards are captured, but it's hard to fit that into a legal claim as to why that would be relevant. Well, under the non-delegation doctrine, it is, and that's one reason why we think this is a meaningful way to pursue the right to earn a living. It's relevant because the courts have said that the motives of the delegatee, the body to whom the legislature is delegating authority, matters. If you think of, for example, to go back to Schechter Poultry, who was writing the codes of fair competition? The industries themselves that were to be regulated by those codes, except, of course, people like the Schechter brothers who were not in the room where it happened, right? So that's what's happening in these occupational licensing schemes, industries making the rules. That's a concern because we're worried that the body to whom the legislature is giving lawmaking authority is not acting in the public interest. And courts have said where the agency or the individual to whom the legislature has delegated power has, quote, skin in the game, end quote, to quote the DC Circuit Court of Appeals, then we're going to apply a higher level of scrutiny to the delegation. We've talked a lot about levels of scrutiny today, and non-delegation typically faces a similar problem to a lot of other claims, which is a high level of deference. But this non-delegation idea in the context of occupational licensing has a way to heighten the level of scrutiny. That is, if the agency, which is the case in most licensing boards, is captured by industry insiders, then we're going to impose a higher level of scrutiny. The second reason why non-delegation claims have a real chance in challenging occupational licensing regimes is because of how broad and open-ended the discretion granted to these boards is. This is really the crux of any non-delegation claim, which is, has the legislature provided sufficient guidance that they're really still in the pilot seat, or have they really given it over to the agency by giving them such unbounded discretion they can make their own rules? Well, it turns out that in many state licensing regimes, they're effectively handing off the driver's seat to the agency. To go back to the Board of Cosmetology in Louisiana, the enabling statute that allows them to regulate the industry of cosmetology literally simply says they can make whatever rules they deem, quote, necessary and proper, end quote, to fulfill the purposes of the statute. Now, that's really no guidance whatsoever, because the court's going to look at whatever they do and say, is it necessary, is it proper? Sure. I'm not going to second guess the Board of Cosmetology, they're the experts. So the board is allowed to do what they want, and you would not be surprised to know that they have used this authority to adopt all kinds of anti-competitive regulations for their industry. So those are the two primary reasons why non-delegation can really make a difference here. One, these boards are captured, so the level of scrutiny is higher. And two, we have largely unbounded discretion granted to these boards. We have a window of opportunity here. We have new research showing that states have meaningful doctrines. We have federal courts that are engaged with the idea of non-delegation like they have never been before. And now is a chance for us to draw this unlikely sword from the stone, just like Joseph Heller and the Schechter brothers in pursuit of the right to earn a living.
That's great. We'll look forward to coming back and digging in a little more. But right now, let's hear from Skylar with your extremely, I think, exciting idea for getting judges into a different mindset.
Oh, good. I'm glad that's quite the opener. So I will start out with this idea that there are stupid laws. I'm sure we can all agree on that. But not every stupid law is unconstitutional. So there's one in particular that I want to talk about. This is an actual statute that is on the books right now in the state of Wisconsin. Quote, no guide license for hunting or trapping may be issued to or obtained by any person who is not a resident of this state. So my goal in the next 6 or 7 minutes is to convince all of you that this is not only stupid, but also unconstitutional. So the basic question here is whether a state can discriminate against a non-resident in an occupational licensing scheme. And the answer to that is no. And the reason why is because of Article 4, Section 2 of the United States Constitution. This is the Privileges and Immunities Clause, which reads, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. It has not been well studied and has often been overshadowed by the Privileges or Immunities Clause of the 14th Amendment. What's curious about this, though, is that the Article 4 clause has been held to protect economic liberty, but the 14th Amendment clause has not. Why is that? So before I get into that, let me just lay out what the current doctrine is, the current jurisprudence for the Article 4 clause. It's a two-step and arguably a three-step analysis, depending on how you want to break it out. Step one is you first determine whether there is a fundamental right at stake. Now, I realize we've criticized the term fundamental rights earlier today. I don't mean to endorse it here, but that is the term that courts use in describing this. If the right is fundamental, then the next step is whether there is discrimination between residents and non-residents and whether that degree of discrimination is justified. And what's interesting here is that this is intermediate scrutiny at step 2. So this might be one of the few areas in the Constitution where economic liberty is recognized as a fundamental right, and I'll give some quotes for that in a minute, but we're not at rational basis. Interestingly, even though it's labeled as a fundamental right, we're still not at strict scrutiny either. So there's something a little odd going on there with this area of law. Now, the seminal case, whenever people talk about Article 4, they talk about the Corfield decision from 1823. This was a justice riding circuit, so it's not a U.S. Supreme Court decision. But as a part of this decision, there was a long, illustrative list of rights that were deemed fundamental for purposes of Article 4. And I'm just going to read one of them here because it's very on point. Quote, the right of a citizen of one state to pass through or to reside in any other state for purposes of trade, agriculture, professional pursuits, or otherwise. Now, the U.S. Supreme Court has repeatedly used similar language in the Hicklin decision from 1978. They said, quote, appellant's appeal to the protection of the clause is strongly supported by this court's decisions holding violative of the clause state discrimination against non-residents seeking to ply their trade, practice their occupation, or pursue a common calling within the state. And to give a more recent example, the Fourth Circuit in 2022 considered a Maryland statute that directed counties to offer defaulted properties to a select class of people comprising largely those living and holding government positions there before listing the properties for a public auction. 3 plaintiffs who are in the business of purchasing tax lien certificates and who are not in that class sued, claiming a violation of Article 4. They won. In their words, this statute violated the fundamental rights to own property and pursue a chosen profession. In the words of the Fourth Circuit, plaintiffs wish to purchase property largely for commercial ends, which fell within the right to a common calling as broadly conceptualized in Article 4 Clause jurisprudence. Now, this line of cases stands in very sharp contrast to the 14th Amendment clause, the privileges or immunities clause that arguably has brought us all here today. And that is because there was a decision called Slaughterhouse. As my colleague here pointed out, Slaughterhouse seems to be the theme of all of these cases. And Slaughterhouse looked at this very similar language in the 14th Amendment and said that only protects rights that are of a national character. And it's not entirely clear exactly what they meant by that, but they did give a couple of examples. For example, the right to access seaports, the right to come to the seat of government, so where we all are here today, and the right to demand protection of the federal government over life, liberty, and property when on the high seas. But as we all know, among those rights that Slaughterhouse protects, economic liberty has generally been held to not be one of them. So the paper that I wrote with my colleague Dan Lennington at the Wisconsin Institute for Law and Liberty does a couple of things. First, it examines whether there's any historical or textual basis for that distinction and largely finds that there is not. The drafters of the 14th Amendment looked to Corfield as one of their supporting reasons for adopting the Privileges or Immunities Clause. And when you read those historical debates, you're not going to see this idea that there's only protection under the 14th Amendment for rights of a national character. And the second reason we wrote this was to try and develop a litigation strategy that might make use of this. So our first kind of call to action is that we would like to see people bring more of these Article 4 clause claims, and preferably claims that have at least a somewhat national hook. So for example, not just a hunting guide, but a hunting guide who wants to engage in waterfowl hunting on Lake Michigan. That would be perfect. Haven't found that person yet, but if anyone knows a hunting guide in the Upper Peninsula of Michigan who wants to travel along navigable waters down Lake Michigan to Wisconsin for being a hunting guide, that would be great. And just to give a second example, in Atlanta, Georgia, there is an ordinance that prohibits non-residents from being taxi cab drivers. So the ordinance reads that applicants must be a resident for at least 1 year immediately preceding the date of application. That is basically the modern day seaport, but instead it's an airport. So the idea here would be to first try to bring Article 4 clause claims, get some good rights describing language, some good precedent, and then ultimately try and use that precedent to advance claims under the Privileges or Immunities Clause of the 14th Amendment and try to get the courts to recognize that there's not really a good reason to treat these, this very similar language as differently as it has been treated. Thank you.
Well, thanks very much for that. And finally, Josh, what I loved about your article reminded me of something kids sometimes do to each other, where somebody one kid grabs the other kid's hand and starts going like this, going, quit hitting yourself. Because you talk about antitrust and the possibilities that it has for challenging crony capitalism. And what's fun about that, right, is that antitrust law is a creature of statute. It was enacted as positive law by the government, which is also in the business of creating these occupational licensing boards that are themselves in the business of stifling competition. So tell us more about how we can use the government against itself.
Absolutely, my pleasure. Good morning, everybody. My name is Josh Polk, and I'm an attorney at Pacific Legal Foundation. Thank you, first of all, to the Cato Institute and also Anastasia and Clark for inviting me here. Today, I'm going to present a strategy for targeting the captured boards that Ethan described using federal antitrust policy, which is usually the great Satan, but here not so much. Well, at least I'm going to make that argument. Yeah, whether you agree with it is up to you. So it's probably no great surprise to most of the people here, but the foxes are guarding the hen houses across the United States. There are approximately 1,800 state regulatory boards regulating everything from occupations to disciplinary actions, et cetera. And a full 85% of them are required by statute to have a majority of board members be active market participants in the regulated field. Worse yet, trade associations are often granted the power by state statute to have a hand in nominating board members. In some states, the governor can only nominate board members for state regulatory bodies from a list provided by the trade associations themselves. One real-world example is the Louisiana Interior Design Board, which by state statute must be staffed exclusively by active interior designers who are members of a particular national industry association. Apparently a common issue with Louisiana statutes and regulatory boards. The problem here is obvious, or at least it should be. Board regulations and enforcement actions stifle competition, often for the direct benefit to the market participant board members. And so there's a clear conflict of interest here. This is not just theoretical. Recent research by my colleague Steve Slavinsky demonstrates that the more captured a board is, the more restrictive the regulations and occupational barriers to entry. But holding boards accountable for anti-competitive behavior is often exceedingly difficult under traditional constitutional theories, which is why we're all here. Thankfully, Tim explained at length what the issue is with a rational basis, so I can be spared the pain and suffering of explaining it again. So I would like to present today antitrust law as a potential alternative or supplement to those theories that have proven somewhat difficult to effectively use. So as I sort of alluded to, and as Clark sort of alluded to, normally those who value freedom, innovation, free market should want very little to do with federal antitrust policy. The reality is that antitrust law is most often used to harm consumers by squashing innovation or protecting really lethargic companies that are allergic to difficult competition. But after the Supreme Court's decision in 2015 called FTC versus North Carolina Board of Dental Examiners, a pro-liberty application of antitrust law sort of emerged and was solidified. For those of you who don't know about the case, I'll just very briefly explain. Back when the Supreme Court issued its decision, the North Carolina Dental Board was composed of 6 dentists who were selected by other licensees and 2 public board members. Those board members engage in an aggressive campaign of sending cease and desist letters to teeth whiteners. If you don't know, teeth whitening is a non-invasive, non-dangerous procedure, often just involving shining a light in somebody's mouth. But the board insisted that this was the practice of dentistry, and therefore they must go after the teeth whiteners for violating the regulations. Well, the FTC filed a complaint against the board, alleging that they'd engaged in anti-competitive behaviors in violation of federal antitrust policy. They tried to claim immunity, but the Supreme Court ruled that Parker immunity, which is basically state action immunity from antitrust policy, does not apply to state boards that are captured by private market participants. This was basically in recognition that there's a clear conflict of interest whenever state board members are participating in the markets that they themselves are regulating. And so after North Carolina Dental, in later cases, a state regulatory body controlled by market participants can be sued under antitrust law when there's one of 2 conditions. 1, the challenged policy or action is not clearly articulated by the state itself, or 2, enforcement of the policy is not supervised by the state. It's really important then to strategically select boards that fail either one of those conditions. And I do have to say that the Supreme Court has not been exceedingly clear about what those 2 things mean and hasn't really had that many opportunities. That's what I'm urging all of you to give it, to, I think, more specifically define those 2 categories, but it has provided guidance that will allow us to strategically select boards for potential litigation targets. For example, for a policy to be clearly articulated by the state, it not only has to be foreseeable that competition will be displaced, but there must be actual evidence that the state intended competition to be displaced. And then as far as state supervision, this is not a rubber stamp. There must be some active supervision by a state official, hopefully one that's politically accountable, like the governor's office or the AG's office, who will then sign off on any anti-competitive decisions made by a particular state regulatory board and ensure that the board is regulating in the interest of the public and not in the interest of themselves. And so if either of those conditions is met, then there is no immunity for the state board, and then you have to prove your antitrust claim, which I think is the hard part and why there hasn't been very many cases a la North Carolina Dental since the case was decided. I don't have time, at least in this initial presentation, to go into the detail about what has to be proven, but basically, under federal antitrust policy, you have to show that there was an agreement to restrain trade unreasonably. And often because people are not saying, hey, you want to go restrain trade, you have to find circumstantial evidence that that's actually what occurred. And so that could be very difficult to do. But ultimately, the point of this presentation is that antitrust could allow liberty litigators to remove power from interested regulators. But beyond that, there's also a legislative angle, because the prospect for a litigation victory in the antitrust sphere could also be used as leverage to secure legislative victories. To browbeat or gently persuade, depending on your style, state legislators into addressing anti-competitive boards and hopefully achieving some pro-competitive reform and pro-economic liberty reform. So there's a couple areas, I think, specifically that the legislature could address, and actually some of them relate to some of the material that was covered by Ethan already. But basically, the legislature could more specifically and clearly define board power and avoid granting vast discretionary authority to interested regulators. Next, the legislature could require real active supervision conducted by more politically accountable officials and offices to rein in anti-competitive boards. And states could also increase the number of disinterested members, thereby diluting the power of the market participants who are currently regulating the market that they have power over. And I'll just leave you all here with an example, which is that we've already seen legislative success in this area when boards are out of control. For example, in Arizona, the state cosmetology board was essentially punished for its aggressive anti-competitive behavior. One thing that they did made the news. A volunteer was giving haircuts to homeless veterans in the park, and then he was investigated for practicing cosmetology without a license. The state responded by increasing the number of disinterested board members, thereby diluting their power and actually eliminating the majority that was held by market participants at the time. So long story short, I think that this could work, and I think it's really underutilized and a big opportunity here. So happy to answer any questions you got.
Thank you. So we'll have a conversation now, and let's sort of feel free to comment on anything you've heard so far that you saw in each other's papers. But I thought I would prompt it with a question to each of you, and I'm going to start with Ethan. I want to preface this by saying I really loved all these papers. They're all really well done. Yours was beautifully written, and I think I encourage anybody, if you just want to see like how you should write, every paragraph is a topic sentence. I knew where I was at all times. I really like your analogies. I'm an analogy guy. I love, and your language is evocative, so I'm going to just read this one quote here. Delegation offers legislators a tool for feeding special interests scraps under the table. Nice turn of phrase. Unpack that a little bit for us, and explain to people who maybe don't appreciate sort of how the motives that legislators have, maybe sometimes to respond to special interests. This gives them a way to essentially pander to those special interests without paying the full political price that they might otherwise, right? So explain how that works with delegation.
Sure, that's a great and really important question. I think it goes back to a lot of our founders' concerns about faction, that there would be these concentrated interest groups that have some particular legislation that they want passed, but the opposition is not as interested or not as directly impacted, not as organized. And so there's sort of this inequality in influence there. But the legislature's aware that it's going to, that it has some public accountability. They're going to want to shift blame and take credit at the same time. And delegation is this really convenient tool for doing all three of these things: catering to a special interest, shifting the blame, you can blame the agency later, and taking credit for what the agency does. Well, we passed the enabling legislation that made this possible. And I think that this is really visible in practice. I mean, this is what occupational licensing is all about. We don't want to pass, we don't want to be seen as unpopular passing some kind of protectionist scheme. Let's let the agency do it. There's a great book written by David Schoenbrod, a very famous book about delegation. His example is marketing orders from the New Deal era. Basically, the marketing orders were technically done by the Department of Agriculture, but were in fact basically controlled by the industries. So the legislation said, basically, make an orderly market. That's about as specific as they got. And then specifically, David Schoenbrod's example is navel oranges. It turns out that the Naval Orange Committee was just completely captured by Sunkist, which is a collective of various businesses. In fact, the employees on the committee were on Sunkist's pension plan. So this was a great example of how this very broad language allowed the legislature to avoid what would clearly be a problem if it was exposed to the public. The legislature's basically amounting to a gift clause problem, right? As they're just doling out gifts to Sunkist, which controls the market. But they're able to avoid all the blame for that by leaving it to the Department of Agriculture, which then nominated a committee, and then the committee is just under the control of Sunkist. So there's a lot of incentive to do this, and I think it's very visible in the National Industrial Recovery Act. Their whole idea was businesses should regulate themselves. It's going to be great. And then they could then avoid the blame for all the problems that come from that, but take credit when it goes well.
Great. Well, thank you for that. Skylar, one of the enduring mysteries about our Constitution is the use of this term privileges and immunities in Article 4, and then we get privileges or immunities in the 14th Amendment. In both places, it's not there by accident, but it's a somewhat idiosyncratic term. It's not one that I think the average reader has a lot of, doesn't have a lot of valence. So one of the parts of your article that I thought was really fascinating, and it was, I guess, a reminder for me, because I think I did know this at one time, but the principal author of the 14th Amendment, or at least Section 1 of the 14th Amendment, Representative John Bingham, had a somewhat different understanding of Article 4's privileges and immunities clause than is currently reflected in Supreme Court doctrine. I wonder if you could take that as a kind of a leaping off point to explain, why the privileges or immunities language was selected perhaps in the 14th Amendment, and the significance of the fact that the author of that provision, or the primary author of that provision, had a different understanding than the Supreme Court of Article 4 language.
Of course. So Representative Bingham did not think that the Article 4 clause was about discrimination at all. He actually thought it was a natural rights guarantee, very similar to the kind of natural rights language that a lot of state constitutions today start out with. And in fact, sort of an interesting historical example of this was when the state of Oregon was trying to become a state, and of course there had to be an enabling act passed, and the state of Oregon wanted to deprive black people of all sorts of rights and wanted to do it in its state constitution. Now, under a discrimination framework, this is not necessarily a problem under Article 4 because it's not about treating citizens of different states differently. It's about treating black residents in Oregon differently. But John Bingham stood up and gave a very passionate speech opposing Oregon's admission to the Union, and argued quite explicitly that the Article 4 clause protects natural rights and is not about discrimination, but actually goes a step further than that. And this is a point that he repeats in speech after speech when you read the ratification debates surrounding the 14th Amendment. And there's also a couple of newspaper articles that were written around the time of the 14th Amendment's enactment that are cited in the paper, and that also kind of take this view that the privileges and or immunities is a very broad concept. It incorporates the Bill of Rights, it protects unenumerated rights, it protects economic liberty, and this is really repeated throughout those documents. And just to emphasize this one more time, when you read those documents, the one thing that at least I did not see as I read them is anything that looks like a sort of slaughterhouse framework about national character or anything like that. I don't pretend to have done an exhaustive read of all of these documents, but that understanding did not seem to be there.
Great, thanks. Going to get to Josh in just one second, but I wanted to say hello and welcome to our online participants, and also remind you that we welcome you, in fact encourage you to submit any questions that you have through the event webpage, Facebook, YouTube, and Twix, Twitter, X, whatever it is these days, using hashtag Cato SCOTUS. I see that we've already got some questions, and we'll get to those in a moment, as well as questions from the audience. But my question for you, Josh, is I've always been somewhat flummoxed by this element of the Supreme Court test that there needs to be the intent to displace competition must be clearly expressed. And I wonder if you could answer it in the context of a specific application that came up in your article where, if I recall correctly, the Texas Dental Board sort of its own accord took a position that in order to provide dental services in Texas, you have to do a physical examination of the patient. But that wasn't written in the statute at all. I know that other boards, including the board that regulates doctors and veterinarians, requires the same. You cannot provide those services without first doing a physical examination. And it strikes me that could be interpreted as a specific intent to displace competition if it's in the statute. But I would assume the state would try to defend it as, well, this is just to protect the health of I guess the person's teeth or the body or the animal. So what exactly, can you tell us more about how the Supreme Court decides whether the intent to displace competition has in fact been clearly articulated?
So as I mentioned, the Supreme Court has not had very many opportunities to explore this question, but they have made clear that it can't be like how Ethan described, where it was you can regulate in the interest of the public or whatever, and that's enough. And so I think to get at what you're getting at, I think that's where the difficulty comes in, because they can say, well, okay, the statute didn't specifically say this, and so maybe we don't have immunity from antitrust liability, but there's actually no collusion going on here, and we're not trying to kill competition, we're just trying to protect the public. And so at that point, you have to find circumstantial evidence that this was in fact the result of a campaign to quash competition. But in that particular case, the state made no effort whatsoever to defend the board, and in fact, almost immediately after we filed our lawsuit, engaged in efforts to prohibit the board from requiring that. So.
Yeah. Well, I want to ask one question. I think anybody who's done significant work on occupational freedom has, I hope, thought about this at one time or another, and that is the deleterious effect that overcriminalization has on occupational freedom and occupational license or economic opportunity. The questioner online said that something like 20 million people in this country have a felony conviction. That sounds about right to me. We don't need to quibble over whether it's 20 or 30, but in many states this forecloses many vocational opportunities, and so the question was, is there anything in this discussion that maybe could be helpful there? And I thought I would kick that over. Anybody can talk about it, but Skylar, I thought I'd ask you about it first, because the current interpretation of the Article 4 privileges and immunities provision is primarily anti-discriminatory. It prevents states from treating citizens of other states worse. And judges seem very willing to do this, and presumably part of the reason is because they get that this kind of parochialism is very difficult to resist in the political process, right? You don't have access, or you're not supposed to have access to the legislature of a state you don't live in terms of voting and so forth. And it seems to me there's a parallel there with people who are looking for work, but they have a felony conviction. In many states, they also don't have access to the democratic process because they've been prevented from voting by felon disenfranchisement statutes. So I invite you to sort of take it from there and tell us whether your program that you describe in your article might be helpful here.
Well, it's an interesting thought that I haven't considered fully. My first instinct is that, again, going back to that two-step framework that's used under Article 4, where you start out by identifying a fundamental right. Interestingly enough, fundamental rights in the context of Article 4 really do mean natural rights, and courts have effectively said that voting is not a natural right. Voting is something that doesn't predate government. It comes into being because of government. So I'm not sure how kind of going after voter disenfranchisement directly would work under that doctrine, but I do think you're right that it's identifying a group of people that don't have access to the political process in that particular state, and there may be some way there to kind of try and go back to at least what Representative Bingham viewed as the original meaning of the Article 4 clause, and to try to advocate for it there and say, look, this isn't necessarily about discrimination between residents and non-residents. It's about protecting natural rights and people who have been disenfranchised from the political process, analogous to the Oregon Enabling Act debate that I discussed earlier. I do also think there's been some movement in that area. In Wisconsin, for example, the legislature passed a statute that established a committee on offender employment. That committee is empowered to issue certificates of qualification for employment. And if a felon gets one of these certificates and a business hires them, they are given a pretty high level of immunity from certain negligent hiring claims that might otherwise go forward. So I do think that's an issue that is fortunately being looked at by a lot of state legislatures right now.
Yeah, I'm reminded that Justice Douglass was the author of an opinion that most of us know all too well, the Williamson v. Lee Optical. What a lot of people don't remember is that 1 year before, and so that's a decision where the Supreme Court essentially just abdicated any responsibility for pushing back against essentially efforts to predate the right to earn a living. A year before, in a case called Barsky, Justice Douglas wrote a passage in which he said, the right to work, I had assumed, was the most precious liberty that man possesses. A year later, he writes an opinion saying that for protection against abuses of your right to earn a living, recourse is to the legislature. There's an interesting, I think, thread here, which is that in the Texas threading case that we talked about before that IJ litigated, my recollection is that I think every plaintiff in that case, or maybe all but one, were non-citizens, right? So to tell them that they have to take it up with the legislature if they don't like the way their livelihood is being regulated is preposterous. You can't say that to a felon in many states. You can't say that to somebody who lives in another state. The through line, it seems to me, is that, again, judges seem willing to recognize that the political process is not a viable avenue for protection or reform in some settings, and in other settings where it is not either, they just miss that, they don't see it, or else they tell themselves a story about how that might be an effective means of pushing back. So I invite any of you to riff on it, and then we'll take questions from the audience. But does that resonate with any of you? The judges seem, there's a weird kind of judicial cognitive dissonance going on here, where sometimes they seem to see that there really is no recourse, and other times they sort of fantasize a recourse where it doesn't exist either. Does that resonate? Josh, you're nodding, so yes, go. And feel free to flail away with antitrust or anything else.
Yeah, and I was just thinking, the reason why I was nodding along is I was just thinking, like, I'm not sure that they actually believe there is political recourse. I think that they just use that as like a crucifix to ward off like political criticism. I remember after the Patel decision was handed down, there was an article written by just some random local news station that was like, he's bringing Lochner back, and it was just really panicky. And I think that happens every time the courts take even a single step towards recognizing economic liberty, and I think they just want to avoid, that's just my opinion, maybe it's amateur psychology, but that's
what
my
you're
perception.
Here for, man.
Yeah.
Anybody else want to sort of run with that, or do you want to take some questions? It's up to you.
I will say on the felon issue, it's very interesting, and if someone were to bring that, I do think in the right test case that could be very persuasive. If it were the person who committed a nonviolent felony and it was sympathetic, it reminds me a little bit of some of the ongoing Second Amendment litigation that we have right now and that's playing out in the courts.
Maybe we can get Rod Blagojevich to move up to Minnesota and get into fishing guiding or hunting or something.
That'd be great.
That could be a fun test case. All right. So happy to take questions from the audience. We have one in the front row, and then we'll go to Anthony.
I was interested to know whether these policies that you're talking about could be applied to the right to work for employer without being required to join or support a union, and also the right to compete for government contracts without being required to require the employees to join or support a union as a condition of getting a government contract. So I've heard of the project labor agreements and President Biden giving preference to people who are union shops or agency shops rather than merit shops.
Okay.
And I'm wondering whether what you're talking about can be applied to that. Thank you.
Yeah, so interesting question. There is, of course, a somewhat separate line of Supreme Court doctrine that has tackled that question more precisely. But does anybody think that the discussion we're having on this panel spills over or has potential implications for, the overextensive presence of labor in some areas?
Mine might. Doesn't directly go to what you're saying, but in my paper I do talk about how in Wisconsin, and I presume in many other states, there are certain kinds of state employment that, for example, require someone to be a resident of the state. And in Wisconsin, there are probably hundreds, if not thousands, of these positions. And if someone lived just across the border in, say, Illinois, and they wanted to drive to work a couple miles across the border into Wisconsin, they would be prohibited from that. And there's no, this is a kind of good point of doctrine for people to be aware of. Under the Article 4 clause, there's no market participation exception. So for some of you who know this, when you get into dormant commerce clause claims, there can be this idea that if the state is involved and is a market participant, there's differences in the doctrine, but there's no distinction made when the state is the hiring body under Article 4.
Anthony, in the fourth row.
Thank you. This is great discussion. So Skylar, I love you bringing up that fact about Article 4 during the ratification of the 14th Amendment, how is it understood, because the irony of history seems to be that Bingham and others understood Article 4 to be a substantive protection, not a type of equal protection clause, and yet they were wrong. They really were wrong about the original meaning. And then when we look at the original meaning of the 14th Amendment, do we take that into account, or how does that work in? So this is kind of just a lead-in for you guys to bring up, whether we're talking about state constitutions or the antitrust laws even, or whatever. How does originalism play into that? And should we be worried about that kind of double-layered originalism of the 14th Amendment when we're trying to work it out?
Well, I suppose I can start. So I would go back to the Corfield decision that I talked about, which I think is probably, even though it's 40-ish years after the ratification of Article 4, probably one of the better sources of original public meaning on it. And it does give a very exhaustive list of fundamental rights. And one of those fundamental rights is the ability to pass through or reside in any state for purposes of trade, agriculture, professional pursuits, so on and so forth. And part of what I'm trying to convince potentially courts and litigators of in this paper is that at least if we're willing to say that's a fundamental right under Article 4, it doesn't really make a lot of sense that we have a different understanding and a very different doctrine under the 14th Amendment. Now, I suppose one way you could go, and that sort of is implied by your question, is you could say that maybe the Article 4 precedent is wrong, but my hope would be that we can convince courts to preserve the Article 4 precedent and also start to look at the 14th Amendment, because of course the 14th Amendment does not have any, at least in the privileges or immunities clause, anything about discrimination. It's not a discrimination-based requirement. So I hope that addresses your question.
I'll just say with antitrust law, Judge Robert Bork basically wrote an originalist defense of the consumer welfare standard in antitrust law called the Antitrust Paradox, which I do recommend. But other than that, I mean, most of the way that judges address antitrust issues is just invented by the judicial system itself. The Sherman Act might be the vaguest statute ever written, and so there's hardly any room for a textualist analysis there. And so the judges simply made stuff up until Judge Bork came around and his view became the prevailing one, but it doesn't have to remain the prevailing one. And so I don't know, I'm just rambling here, but it's originalism does have a place, I think, in antitrust policy, to the extent that antitrust policy must continue to exist.
Well, I want to close it out with our question we got online. I want to thank Cameron and W for this question. It's a really excellent question to wrap up with. I think particularly for this panel, because you were so much closer to the answer than some of us, including me. Cameron says, I'm a current law student, excuse me, and I'm the only law student I personally know who cares about economic rights. How do I change that? Let's come down the line. Why don't we start with you, Josh, and we'll work towards me. So what do you think?
First of all, I think stories and examples, we got a bunch of those from the first two panelists. I think they were really great, and I think that's how you change hearts and minds. But also, not just the poor grandmothers who are being put upon, but also the outrageous actions taken by the government itself. So one of the examples in my paper that Clark mentioned was when the State Dental Board of Texas tried to ban, without any sort of statutory authority, teledentistry during the pandemic. So they basically said, you can't go see your dentist in person, and oh, by the way, you also can't see your dentist over the phone. And I think that's obviously stupid and irrational, and I think stories like that sort of help us sell it to the public. So.
Yep.
The Board of Bar Examiners is arguably one of the most abusive processes that anyone has to go through. And I will just say from personal experience, you will see a lot of people start to care about something that looks a lot like economic liberty when they're a third-year law student. And I served in the Army for a number of years and had a security clearance. And I will tell you, getting a security clearance, even a high-level security clearance, is a lot easier than getting admitted to the bar. So maybe that's a way to kind of connect the dots for law students and help them see how this kind of stuff can affect them personally. And if anyone wants to sue the bar, please talk with me.
Great. Go ahead.
Well, I'd say more generally that our law, especially our constitutional law, is shot through with this Puritan notion that when you're in it for money, all of a sudden your rights are reduced. This is true in the First Amendment. If it's commercial speech, doing it for money, we're going to reduce the protection that applies to you. And it's in our statutes, right? There's charitable exemptions out there for license. It's okay for you to do such and such without a license if you're doing it for charity. If you're doing it for money, you have to have a license. And so I think we can push back against that by telling stories about people like the Schechter brothers, right? These are the people that are protected by economic liberty, not, right? It's who's writing the regulations under the National Industrial Recovery Act. It's not the Schechter Poultry, the Polish Jewish immigrants who don't speak English. It's the powerful, and I think that should resonate with law students, right? These are people who should be, I think, in the political climate we're in, concerned about the little guy, and we need to help people recognize that the little guy is the one that's getting the short end of the stick.
Impossible to improve on those answers. Those were great. The power of stories and appealing to self-interest. It's a great combination, so thanks for that. Please join me in thanking Ethan and Skylar and Josh for a great panel and for the effort they put into their papers. And come back at 11:45. We're going to hear from Dr. Narang about entrepreneurialism in India. So thank you. Go have a break and come back at 11:45. All right.
Welcome back, everyone. I'm here to introduce our final speaker who will be doing a TED Talk of sorts based on his excellent TEDx talk that you can find on YouTube. It's truly wonderful and inspiring. I'd like to introduce Dr. Prashant Narang. He's a postdoctoral researcher at the NE Regulatory Research Center at West Virginia University, specializing in regulatory policy research. His work examines the impacts of a license raj on the auto and cycle rickshaw sectors and explores regulatory barriers in live music and dance performances in bars and restaurants, as well as in professions like litigation, street vending, farming, and K-12 education in India. Dr. Narang's doctoral thesis provided a critical analysis of judicial standards of review in Indian constitutional cases concerning the freedom to pursue a livelihood. Just in speaking for some brief moments with Dr. Narang, I was just astonished to find the parallels between economic liberty cases in India and the United States, and even some of the cases that I litigated. And so I hope you all find it poignant and central and moving and inspiring. And without further ado, here is Dr. Narang.
Thank you, Anastasia and Cairo, for having me here. I've been following the discussion since morning very closely with great interest, taking notes, and I hope that you will find some interesting key takeaways and some answers to your questions, especially related to storytelling from this talk. So good morning, everyone. Let's time travel back to the vibrant streets of 1980s India. Picture this scene. A flurry of cycle rickshaws bustling through the crowded markets. Back then, there was a peculiar rule. Only if you pull the rickshaw can you own it, which means one person, one rickshaw. A person couldn't own multiple rickshaws. Why? Because if you own multiple rickshaws, you would be a capitalist, greedy, rickshaw owner who would give it on rent to the poor rickshaw pullers and exploit them and earn money. And so this law, a product of the license raj, was intended to protect the hardworking rickshaw pullers from the so-called greedy rickshaw owners. This law was challenged 4 times because this law prevailed in multiple states. So twice, the rickshaw owners challenged it, once from Delhi and once from Punjab, and twice the rickshaw pullers challenged it. Right? And 4 times the Supreme Court of India, which is akin to the Federal Court of the United States, upheld it, believing that it would foster equality. But did it? It did the exact opposite. And I'll give you the example of Muhammad Zia, a young dreamer from West Bengal who migrated to Delhi with hopes as his only capital. Barely he had any money. He started by renting a rickshaw. He saved some money every day, and he bought one rickshaw after a few months, and then another, and then another. By 2010, when I met him, he owned 110 cycle rickshaws. So he escaped poverty, he became an entrepreneur, but in the eyes of law, he was a mafia. Right? So Jia's journey should have been applauded. Instead, he found himself unfairly labeled as mafia, thanks to the very law that was meant to protect him. Imagine being called a mafia for scaling up a business. It's as absurd as suggesting that an airline owner should pilot each plane themselves, right? And with a cap on rickshaw licenses, any number beyond the limit would be deemed illegal, leading to rampant seizures and a fertile ground for bribery and corruption. Now, everything changed in 2010. An NGO called Manushi challenged these socialist laws. Their argument wasn't framed as a rich versus poor argument. They highlighted the systemic harassment of rickshaw pullers by police and municipal officials, right, to change the narrative. This new angle shifted the focus from greedy owners to an oppressive regulatory regime that hampered the dignity of livelihood for both owners as well as the pullers. The Delhi High Court was compelled to listen, and the oppressive law was finally overturned. Okay. This is, sorry. Yeah. So you see the words that they used during their brief, when they filed the brief for litigation. So the narrative changed, right? It was worded in terms of bribery, corruption, license raj. So as we delve into our discussion today, we'll explore how narratives and third-party interests shape our battles for economic liberty and influence their outcomes. In what ways do the stories we embrace and the viewpoints we advocate shape the contours of justice? So let's unpack some of these ideas together. But before that, let me first also tell you a little bit about the Supreme Court of India and the freedom of livelihood, which is enshrined in the Indian Constitution. So Supreme Court was initially quite literal in its interpretation, followed textualism, originalism, focusing mainly on the text. Then gradually, the court started to consider part 4, which is directive principles. And some of these directive principles are hardcore socialist ideals, right? And so this led to decisions aimed at particular outcomes rather than strict adherence to the text of the rights. And this shift also led to very inconsistent decision-making. The court became more deferential to the government's assessment of what constitutes reasonable restrictions. So if you look at the right is in part 3 of the Constitution, under right to freedom. It says all citizens shall have the right to practice any profession or to carry on any occupation, trade, or business. There is a corresponding article which talks about what the state can restrict. So it says the state can make any law which is a reasonable restriction in the interest of the general public. So these are 2 qualifications, right? So scholars have noted that judiciary often avoids a deep dive into these issues, opting instead for a more deferential stance that focuses narrowly on whether the restrictions are reasonable, rather than examining whether they genuinely serve the public interest, right? And so this doesn't necessarily offer a good, genuine, authentic judicial review. There is also a lack of research in India into how the justices' own ideologies might influence their decisions regarding economic liberties. There has been very less work on judicial ideology and the outcomes. Okay. So what happens when there is an economic restriction and a business challenges that economic restriction? The state defends it, right? So they are the 2 primary parties, the business and the state. But what about a third party, right? Who can this third party be? Apart from business and the state, sometimes third parties such as labor union or consumer association or sometimes environmental advocates can also be deeply invested in these legal battles, right? And their involvement stems from the fact that they may also be directly or indirectly impacted by some of these regulations. These groups may align with the businesses, and these groups otherwise, if it's a zero-sum game, they may try and defend the economic restriction, right? So what I did in this study is utilizing the legal databases. I filter for the relevant Supreme Court cases between 2010 to 2024. And I look for the cases that involve this Article 19(1)(g). Then I look for cases that have third-party interest. So what I'm trying to do is to identify cases that have third-party interest which are aligned with businesses and cases where third-party interests are not aligned with businesses, and then look for the variation in outcomes, right? So I look for alignment of interest. I examine whether third-party interests are aligned with those of the businesses or they are in conflict. Nature of the economic activity, core rights at stake. So apart from 19(1)(g), if there are any other fundamental rights at stake. So for example, it could be freedom of speech and expression for a third party, or it could be it could be right to life for a third party, or it could be an issue of environment for the third party. Right? So, and then what is the outcome of the case? So I find in a total of 13 rulings and 13 judgments involving significant third-party interest. Out of these 13 cases, 9 feature non-aligned interests between businesses and third parties. Right? This is the stack bar, not aligned. And out of these, if you see 8 decisions upheld the economic restrictions, which means business lost and the economic restriction was upheld, and the third party interest, they were also upheld, right? So only one decision went in favor of the business where their interests were not aligned with third parties, okay? And that sole decision which went in favor of the business was a dissenting opinion. So I counted dissenting opinion as a separate ruling, and that was a dissenting opinion. So not very optimistic scenario for businesses if their interests are not aligned with third parties. Okay. Out of these 8 cases, the remaining 8 cases, 3 rulings summarily rejected the claim without doing any proper review. Okay. Another 3 rejected the challenges based on the premise that this is a restriction which is in furtherance of the directive principles, the socialist ideals enshrined in the Part 4 of the Constitution. So you don't need any review. We assume that this is a reasonable restriction and this is in public interest, so no review needed. 2 left. And the remaining 2 were related to state conducting a common admission test for admission to private medical schools. The first of those rulings took a partial proportionality test while referring to precedents. And the second one, of course, treated the first one as a precedent and upheld the restriction. So these were the 8 decisions. Now we come to this bar. I don't know if this is visible to you, the aligned one. There are 2 cases where third-party interests are aligned with the business interest. The first case centers on language of instruction in private schools. So what is the medium of instruction? Parents wanted English to be the medium of instruction because that allows better job opportunities, better future prospects for their children. But the government wanted the regional language to be the medium of instruction in private schools. And the experts, the education experts, the linguistic experts were also of the opinion that the children should be educated in their mother tongue. Right? Here is what the court said. The court affirms parental rights to choose their medium of instructions by locating it in students' freedom of speech and expression. But they also upheld the private schools' autonomy to choose medium of instruction. But first comes the parental right to choose medium of instruction for their children by locating it in the children's right to freedom of speech and expression. Okay. The second case involved prohibition of bar dancing. And bar dancing is, the common objection against bar dancing is a moral objection. It's considered to be a social stigma. They say it's a very cheap or obscene dance being performed by women in beer bars, and so on and so forth. So the court sided with the dignity and labor rights of the women against claims of obscenity, supporting both the business's operational freedom and the worker rights. So these decisions also underscore that where the third parties are aligned with business interest, the court tends to favor the business right, and it could be in the name of human dignity, it could be in the name of fundamental right, but those rights are upheld. Now we come to mixed alignment of rights. When I say mixed alignment, what does it mean? So there was one case which involved, was filed by an NGO against mandatory iodization of salt. So there was a law that the company must add iodine to common salt, kitchen salt. And an NGO challenged that, saying that the whole of India doesn't need iodized salt. It's against consumer choice. But they also invoked Article 19(1)(g), saying that only the larger corporations tend to gain out of this rule, out of this regulation. It's against the interest of small manufacturers, small and medium-sized businesses. So you should do away with this restriction of mandatory iodization and let the consumer choose. Because India has a large coastline where people don't need mandatory iodized salt, and only some states or some districts would need that. The court rejected the claim based on Article 19(1)(g), based on the constitutional freedom, but they struck down the regulation based on non-delegation doctrine. So this also was in favor of the third-party interest. Although they didn't upheld it, they didn't favor it based on the 19(1)(g) freedom of livelihood principle, but they struck down the regulation based on non-delegation. The second one was also bar dancing case. So there were 3 bar dancing cases. 2 were from one state and the third one was from another state. And here, so the first one involved a direct ban, but this one had licensing for bar dancing. So the bar or the restaurant had to obtain a license, but there were specific conditions. And I'll discuss that in detail. That was partially struck down and partially upheld. Yeah. Okay. So what do these findings indicate? Right. So there is a previous study done by Chilton and Westig, which explains why the effectiveness of independent courts in enforcing constitutional right is not as straightforward. There are 3 reasons which are particularly relevant given by these scholars. The first reason is when the courts frequently challenge political branches, they risk facing court curbing measures. It could be like altering jurisdiction or appointing sympathetic judges. Second, courts might sidestep contentious issues using legal doctrines or deferral techniques to avoid clashes with the political branch. And third, courts also often issue decisions that mirror the majoritarian preferences. It's a strategy for them to maintain their own legitimacy and public support. And third-party interest can at times be majoritarian interests. So these 3 factors combine to explain why the role of courts in enforcing constitutional right is more limited than commonly perceived. So if we see it in totality, out of 13 rulings, 12 are in favor of third-party interest. And the only unfavorable ruling is actually a dissenting opinion. Right? 8 out of 9 rulings favor state-imposed restrictions and third-party interest over individual freedom. And this is particularly noticeable in cases involving education, morality, and environmental concern. So while focusing on credibility and legitimacy, there might be a diminished adherence to the rigorous standards of review, and I'll discuss that in detail, that when the courts decide a case in favor of third-party interest, do they really care about judicial review or the standards of scrutiny? Okay. So this case is about the language of instruction. So in this case, despite facing opposition from experts, courts upheld the rights of parents to choose their children's medium of instruction alongside the school's freedom to determine their educational approach. So what it reveals is an interesting pattern that businesses that align their goals with broader societal, consumer, or labor interests, they tend to succeed more in legal challenges. The parent association was a party to this matter in the court. And both the schools as well as the parents had a sort of a common ground, had a common end to achieve, right? So it highlights the judiciary's dedication to upholding choices that align with collective interest of communities, such as parental rights and autonomy of educational institutions. There are two more cases that involved the question of educational institutions' autonomy, but there the outcome was different if we compare it to this one. But before that, I come to the bar dancing cases. There are 3 judgments on bar dancers. 2 are from Maharashtra and 1 is from Karnataka. And in Maharashtra, the bar dancer unions were also party to the cases. Right? They formed associations and unions, and they became party to the cases. And there is a series of cases, but in those 14 years, there are 2 cases that reached the Supreme Court. The first case was about, it challenged the ban on bar dancing. And the court was very clear that this ban was unconstitutional, and citing the grounds of human dignity, with gender perspectives, they struck down the ban on bar dancing. Right? And then there was another round, because the state government, then after the ban was struck down, they came up with a licensing regime on bar dancing. They also had regulations on bars and restaurants that they had to do there were some welfare conditions for bar dancers on how much to be paid and the mode of payment, salaries, etc. But also specific conditions on the size or the dimensions of the dance floor, how much distance to be maintained between the bar dancers and the audience, and so on and so forth. And in the second time, while there were such nuanced, detailed restrictions, the court, while upholding the licensing regime, struck down some of these detailed regulations. Again, the ground was that it violated the autonomy of bar dancers. So much for the autonomy of bar dancers and for the parental autonomy, right? But what about the autonomy of businesses? And so the court has a different stance, because if you look at the Karnataka case, which is the third case, and which was about live music performances in bars and restaurants in Karnataka, that was also a licensing regime. One thing differed in Karnataka, which is actually 2 things were different in the Karnataka case. One is that there was no representation of the labor. There were no bar dancers or live music performers that came to the court. So there was no representation. And second is, while it also involved licensing regime, the grounds of restrictions were delegated to the agency, and these were very broadly worded grounds. So the ground also said that anything which is in the public interest, and so on and so forth. So there were 3-4 grounds which were broadly worded, but the court didn't really do a rigorous scrutiny of those broad grounds. Whereas in the Maharashtra case, they rigorously scrutinized the detailed restrictions. So the Karnataka law was upheld. No restriction, no regulation was struck down. But in Maharashtra, the first matter, the ban was struck down in toto. And in the second one, some of the regulations were nullified. Now I come to a third case study, which is nationalization of 25% seats in private schools. And this is also related to education, but the incentives, the interest of the consumer, which is the student, and the interest of the business, which are the schools, they are not aligned, right? Because it's a zero-sum game. The seats are reserved for the 25% seats in a private school would be reserved for students from economically weaker section and disadvantaged communities, and the government would pay or would reimburse to some extent to the school for these children. So this law was challenged. There were two opinions. One was a dissenting opinion. The dissenting opinion is very detailed. It looks at all the precedents. It looks at the legislative debates, the legislative history, and the judge writes a very detailed opinion undertaking a detailed scrutiny of the restriction. And he strikes down the economic restriction. And that's the sole opinion which upholds the business interest, trumping the third party interest. But that's a dissenting opinion. And whereas the majority opinion, sidesteps, bypasses the scrutiny, it doesn't take any sort of detailed scrutiny because they find that this law is made in furtherance of the director principle, and hence it is assumed to be reasonable, assumed to be in public interest, and they uphold it. Now, the difference in these two opinions also opens up a broader conversation about what truly makes a court's decision legitimate and credible. Is it just about going with the majority sentiment, or is it about grounding decision in solid, thorough legal analysis? And while thinking about the dissenting opinion, I mean, the dissenting opinion is very good, but unfortunately, it couldn't do anything good for the business interest. So while thinking about it, I was also thinking that there is also a hint that those opposing the quota might have missed a trick or two in their legal strategy. Perhaps suggesting alternatives like voluntary reservations or direct cash transfer could have swayed the other two judges in their favor. These kinds of innovative legal ideas not only challenge existing policies, but also add depth to the judicial discourse, showing how courts can help mold policies that are both legally robust and socially beneficial. So, what are the lessons for advocates of economic liberties? Navigating the judiciary's dual goals of protecting the downtrodden while also maintaining a smooth relationship with the state is no small feat. The Balancing Act reveals a paradox where the defense of liberty, including that of businesses and entrepreneurs, sometimes takes a backseat, especially when it is against the interest of third parties. So for legal advocates focused on economic liberties, it requires a strategic approach. Advocacy here transforms into an art form, requiring a deep understanding of judiciary's aspirations to both shield the marginalized and avoid clashing with the state. So lawyers then need to craft arguments that not only speak to judiciary's commitment to social justice, but also highlight how economic liberties are crucial for societal well-being and can actually benefit those less privileged. This means lifting up those often unheard voices in the courtroom and aligning cases with the judiciary's self-image as champions of the underprivileged. So it's very important to also bring out the second order effects of an economic restriction, right? If we believe that an economic restriction is bad for business, and not just bad for business, but also for the society overall, I think that point needs to be really made very well in the courtroom, right? So the trick is to show how safeguarding economic freedom can uplift the downtrodden without painting the state as the bad guy. And framing legal arguments strategically is the key. It's about showing how economic liberties promote dignity, inclusivity, and improve lives, all while supporting the state's broader ideal of justice and equity goals. So to sum up, advocating for economic liberties turn into a nuanced storytelling exercise. It's about recognizing judiciary's intent to support the marginalized and certainly making the case that true social justice includes economic freedom as well. It doesn't just aim for favorable outcomes, but enriches judicial discourse, deepening courts' understanding of how economic liberties serve the collective, the common good. And it can also push towards a more equitable and just society. Thank you. Okay. It's already 12:15, but can we take a question? Okay.
How would you eliminate the elimination of all vestiges of the licensing rush since the 1990s, and how would you kind of evaluate that's effect on the just general rule of law in India, especially just with regulatory compliance and reduction of black markets for products and services?
So your question is about in terms of how, as a strategy, as a judicial strategy or a litigation strategy, how we can challenge the license rush?
I would say more specifically, like, how has, like, okay.
Thank you. I was more asking specifically, there's been some progress towards, I would say, eliminating like the worst aspects of the licensing rush since the 1990s. And I want to ask, have you seen any changes in the general rule of law, like reduction of black markets for products and services within India as a result of these small incremental changes?
Oh yes, definitely yes. Yeah. So since 1990s, the sectors that saw liberalization in 1991, black markets have disappeared. And people now can see. It was very difficult to make that argument in late 80s or before that. Even in the early 90s, it took some time for the markets to show results. But gradually, and now, if you ask the present generation, for them it is very difficult to believe that we had all those sort of restrictions before 1991, because people are now so used to freedom and not seeing black market in some of those areas. And often when we have to explain it to people, we show comparison of sectors which continue to be heavily regulated, like education and agriculture, as opposed to any other sector, for example, IT or other industries, or let's say Bollywood. So some of those sectors are pretty liberalized as opposed to education. And so most of the problems, if you ask any Indian, give me 5 areas where you see most problems. And often these are the areas which continue to be most regulated, are the problematic areas. Yeah. Thank you so much.
Thanks to Dr. Narang, and thanks everyone to joining us. And if you have time, we'll be having lunch 1 floor up.